In the case of Atkins v Virginia 2002, the Supreme Court ruled that the Eighth Amendment prohibits the execution of defendants with intellectual disability, claiming that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Today we are here to discuss whether IQ should have an influence in sentencing in courts. Good morning, ladies and gentlemen. Calling the case of the murder of Paul Goddard committed by Ms. Kezia Wheeler and Mr. James Halliday, both of whom pleaded guilty to first-degree murder in our previous trial. Are both sides ready? Do you, the jury, swear that you will fairly try the case before this court and that you will return the most suitable decision according to the evidence given and the instructions of the court?
On the evening of the 12th of November 2016, Paul Goddard had just finished his final lecture of the day. He left the University of Lincoln at 5:40 p.m, headed home. At 6:26 p.m, his body was discovered by a local passerby in the Brayford Pool. The two defendants in question were spotted leaving the same university at 5:54 p.m, shortly after Mr. Goddard. Due to their personal vendetta with the victim, there is absolutely no question of their motive and that they committed the crime. And today we're here to gain justice for the Goddard family and the fellow lecturer Patrick Hilton, ensuring that the two defendants receive a sentence deserving of their crime. Mr. Halliday, at the time of the following and then the murder of Mr. Goddard, were you aware of your actions would lead to the death of Mr. Goddard?
No, we just meant to scare him, to teach him a lesson. Because he gave us an unfair mark on our assessment, we should have gotten a first, but he only gave us a third. We just wanted to scare him so he would give us a better grade. We didn't mean to kill anyone.
And Miss Wheeler, at the time of following and then murdering Mr. Goddard, were you aware of the potential outcome of your actions?
I swear we didn't mean it to end like this. We just wanted to scare him, not kill somebody.
The two defendants on trial today have below average intellectual functioning, as they both have an IQ of below 75. Miss Wheeler has an IQ of 71 and Mr. Halliday has an IQ of 69. How can we allow these two individuals to be sentenced to the death penalty when they clearly do not have the intellectual ability to appreciate the consequences of their actions?
I strongly disagree, Your Honour. It has been shown that mentally retarded individuals frequently know the difference between right and wrong and are competent to stand trial. This competency was categorised by the Supreme Court as whether the defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him.
The cut-off point for whether the defendants are smart enough to be killed is too black and white. How can the law state that one defendant should be given the death penalty and one be allowed to live the rest of their life, albeit in prison? The difference in IQ is mere 2 points, and yet that is enough for Miss Wheeler to be put on death row, essentially ending her life for this crime. But Mr. Halliday be allowed to continue to live. Neither defendant should be given the death penalty, as the IQs are much too low for them to be able to understand and fully know the consequences of their actions. Not only this, but the result of the IQ test could be affected by outside factors including gender bias, as it has been found that females generally tend to perform better on IQ tests than males. 2-point difference in IQ between Miss Wheeler and Mr. Halliday could nearly be down to the fact that Miss Wheeler is genetically predisposed to perform better on the test than Mr. Halliday as a result of her gender.
IQ testing does not take into account other factors within intelligence, such as emotional and social intelligence. So despite their low IQ scores, they may be much more intelligent in reality than their scores are suggesting.
The clinical definition of a mentally retarded person is that they require not only sub-average intellectual functioning, but also significant limitations in adaptive skills such as communication, self-care and self-direction that manifest before the age of 18. In 1988, legislation was passed in the US, stating that a person who is deemed intellectually disabled may not be sentenced to death. They suffer from disabilities in areas of reasoning, judgment and controlling their impulses, meaning that they do not act with the level of moral culpability that characterises serious adult criminal conduct.
As a result of their impairments, by definition, they have diminished capacities to understand and process information, to communicate, to abstract from mistakes and learn from experience, to engage in logical reasoning, to control impulses, and to understand the reactions of others. This, therefore, suggests that they were not fully aware of the consequences of their actions and so should not be given the death penalty.
Miss Wheeler's IQ is above the cut-off point of 70, and Mr. Halliday's IQ is only 1 below. The average IQ in the US falls between 80 and 120. Their results are only 10 points below the lower end of the range. Therefore, I would argue that both defendants do not have significantly diminished capacities and should still be held responsible fully for their actions.
How can we argue that sentencing should be based purely on the IQ of these two individuals? IQ testing has many methodological issues, and so to base a life or death decision on such a flawed and valuable test is ridiculous. It has been shown that IQ testing suffers from practice effects. In Catron and Thompson's study, this found that there was a 3 to 5 point increase when an IQ test were repeated a week later. Had our defendants previously taken part in an IQ test, their current scores may be higher than is accurate as a result of practice effects, so should not be considered.
Should we not then consider the Flynn effect, which states that IQ scores tend to rise 5 to 25 points in a single generation, and this is accompanied by the test being made harder every 15 to 20 years, and genuinely, IQ scores rise around 2 points per year. Although Mr Halliday's score is below the 70 mark now, doesn't mean it still would be this time next year.
As a result of the Flynn effect, could we not argue that the defendant's IQ was lower at the time of committing the crime, meaning that both Miss Wheeler and Mr Halliday's IQ scores would fall below 70? This then brings in the question of the time in which we have to measure the defendant's IQ, whether it be at the time of the crime, trial, or before execution.
Many psychologists argue that IQ should be measured as near to the time of the crime as possible, as the IQ at the time of the crime is what is ultimately affecting their culpability. And in some cases, a defendant's IQ may increase while as a result of the trial, putting them above the IQ cut-off line, even though they scored below 70 when they were initially tried. So it's crucial that the time of IQ testing takes place at the time of the crime. A defendant's IQ could change from above to below the cut-off point, and vice versa, in remissions similar to that of a psychotic disorder. One IQ test may indicate 76, while another is 68, even when there is only a short time between the two tests. IQ is changeable over time, so unless one time of testing is decided on, then results in cases such as this one could be impossible to decide.
How do we know that these defendants did not intentionally corrupt the results of IQ tests to try and avoid being given the death penalty? Both defendants could have manipulated their IQ score by not acting to their full potential, knowing that their low IQ would prevent them from being put on death row. We should ignore their IQ score, as they must know that murder is illegal, so they must be able to understand that what they were doing was wrong, and so should have to face the same punishment as other murderers.
Intentionally manipulating a test would require a higher level of intelligence than either of the defendants could possibly have, and thus it would be almost impossible for the defendants to deliberately make their score as low as it is.
Canadian law states that the criteria for a defendant's fitness to stand trial involves comprehension of the court proceedings, knowledge of one's legal rights, knowledge that the charge is punishable and that the degree of punishment depends on the crime, and knowing what to do.
Judge, I wish you to consider this. How could two adults not understand that their actions would lead to murder? Both defendants are adults and they must be able to, therefore, realise the consequences of their actions irrespective of their below average IQ scores, and should therefore not be given a lesser sentence.
But Judge, please also consider the fact that in current law, the cut-off point in an IQ score of 70 has seen in Hall v. Florida, and so if a person's IQ falls below this, then no more evidence should be considered to convince you that the defendant is intellectually disabled. This rule implies that even those who have an IQ of over 70 and have an intellectual disability such as autism cannot be judged to be intellectually disabled. In a court of law, it is your decision whether you consider the defendant's IQ when sentencing them.
Jury, when making your decision, I implore you to consider all of the information the defence and prosecution have provided for you today.
The defendant's IQs are low enough to be classed as an intellectual disability, so we should be helping them understand what they have done and not punish them as though they're normally functioning adults. Research by Candle et al. Found a correlation between growing up in an environment where crime is the norm and low IQ. Many psychologists would argue for rehabilitation rather than just punishment for both defendants, as their crime could be argued to be the result of their poor upbringing, leading to them not understanding the difference between right and wrong, as well as not being able to fully comprehend the possible outcomes of their actions.
We have decided that the defendant's IQ should not be considered when sentencing them. It is unfair to give these two defendants different treatments when they both committed the same crime and their IQ is so similar. There is only a difference of 2 points between the two defendants, so how can we claim that one of them understood their consequences of their actions but the other did not, when this difference is so minor?
To conclude, I have said that IQ should not be considered when deciding whether the defendant should be sentenced to life imprisonment or the death penalty. This is due to the flaws in IQ testing such as the Flynn effect, gender bias, and the fact that the cut-off point was 70 because too black and white when considering something as complex as a person's intelligence. Furthermore, our two defendants are only 2 IQ points away from each other, so it seems impossible that they would be given different sentences for the same crime. Also, it's possible that our defendants could have deliberately manipulated their IQ score in order to escape the death penalty. So in conclusion, I'm ruling that both defendants will receive a death sentence regardless of their respective IQ scores.